Hello, everyone. We have with us today Senior Advocate Rakesh Dwivedi, who argued for the state of Madhya Pradesh at the same-sex marriage case in the Supreme Court. Mr. Dwivedi's arguments were accepted by the Supreme Court. In fact, Mr. Dwivedi had presented a statistical analysis of how different countries had gone about, when they were legalizing same-sex marriage, and how it has worked on different jurisdictions. And the Supreme Court has, in fact, accepted Mr. Dwivedi's arguments on the legalizing or legal sanction to same-sex marriage being the job of the legislature, the parliament. Welcome, sir. Thanks for being here.
Thank you.
Yes, sir. So my first question to you would be, what is your overview of the judgment, sir? What do you think the judgment does? Is it on separation of powers rather, and how does it address these issues, sir?
So the judgment is actually very, very important because though in the context of same-sex marriage, the Supreme Court has gone into the question as to what is the demarcation between the domain of the legislature and the judiciary. So how far can the judiciary issue mandamus to the legislature and the state executive when high policy matters are involved and legislation is required, because it is a long-standing view of the Supreme Court that the courts cannot issue mandamus to the legislature to make a particular kind of law. And so far as the executive is concerned, it is also a consistent stand that when complicated policy matters are involved, then it is for the executive, the policy makers, to make the policy, and the court cannot initiate the same. So the only limited domain is where discriminations are happening pursuant to a policy already made or a law already made. Then, of course, the court can try to equalize by issuing mandamus. So it was in this backdrop that this question arose. And its significance lies in the fact that over the previous years, particularly in Aadhaar case, Puttaswamy's judgment, the Supreme Court for the first time recognized that there are positive obligations on the state to create an atmosphere, to create a space, a framework of law to enable the people to exercise fundamental rights. So this is for the first time this question got involved, that how far the court can go to impose those positive obligations. What is the extent of the positive obligation? And where does the court stop? And in fact, Justice Bhatt gives a very interesting illustration. He says that supposing in an area the roads are not there and people have got a fundamental right to travel, can the court go ahead and issue a direction or mandamus that you make the road? And can it also say that since you have made a road in the nearby area, you make the road here also? Because all that involves financial implications, priorities, etc. So whether the money should go to the border area for making the road, or whether it should be spent to make the road from Delhi to Meerut, etc. So these are not where the courts can enter into. That is the view taken by him. So this importance is, what is that positive obligation? How can the court, to what extent the court can issue mandamus to the state in that regard?
Yes, and for your arguments, you had spoken of how different countries had worked around the same subject. You had spoken of how only 34 countries of 194 countries had given legal sanction to same-sex marriage, and of those 20 had 20 were directed by the courts.
Yeah. So that's what we were asserting. Both the Solicitor General, Mr. Tushar Mehta, he also did a very wonderful job in bringing about how separation of powers, etc., has worked in India in different case laws, and how this cannot be accommodated in the Special Marriages Act by altering the fabric of it, which is something legislatively done. And we were both struggling to convince the court, and we are very happy that the court has accepted this position, because marriage was existing much before Article 14, 19, and 21. So it's not a something which is emerging from this. Marriage is a kind of union, but it is more than a union. Especially amongst Hindus, we pointed out that Hindus, we consider it to be sacred. All right, there are developments now. Divorce has become a little more easier. Courts are also a little inclined to separate if there is fundamental breakdown of marriage. But the substance of it still remains that it is a sacred relationship. And even amongst the Muslims, and going by Islam, though it is marriage happens in the presence of Qazi with Kabul hai and Kabul hai, but ultimately, why do we need the Qazi? So there is an element of sacredness attached to the marriage. So their divorce procedure may be easier, but notwithstanding that, so therefore, in the Indian context, the marriages are sacrosanct, sacred, and they are not like we don't need to imitate and follow whatever is good for America and United Kingdom is good for India is not the correct approach. So we labored very hard to say that marriage is not a part of fundamental right. And in any event, there is no similar kind of more marriages which can be accommodated. So one of the pointed question of, in fact, of Justice Bhatt was, where do you locate marriage? It could be association under 19(1)(c), it could be 21. So I said that, well, you locate it wherever you wish. The point is not which part of the Constitution allows us to keep on marrying. Point is whether other sorts of marriages can be contemplated, created, and then thrusted into the domain of Article 21. So that's how, and we are happy that the majority judgment at least has accepted completely our submissions, that right to marriage or a right to a particular kind of union doesn't exist in.
Yes, sir. And another interesting aspect of the judgment is that it has clarified that transgender persons in heterosexual relationships can marry under existing personal laws. What is your take on this, sir?
So transgender is one category of the LGBT plus community which stands somewhat in a different pedestal as compared to the other groups in that.
There is also this aspect of granting benefits to same-sex couple. Even if the marriage is not legalized in the near future through a parliamentary legislation. Justice Bhatt, for instance, in his judgment speaks of gratuity and other benefits, being granted to same-sex couples. What is your opinion, sir? He's asked the high-level committee to, of course, consider it. What is your opinion on that, sir?
The first aspect is that the judges have left it to the high-powered committee. And that is also because during the arguments, many of the petitioners were pointing out some of the practical difficulties which are arising. Namely that they are not able to open joint bank accounts, or some traveling or inheritance and so on. So in that context, the learned Solicitor General Shri Tushar Mehta had taken instructions, and he had made a clear statement in the very beginning that we have decided to constitute a committee, high-level committee headed by the Cabinet Secretary, and they will look into the various problems, and the petitioners can draw the attention of the said committee to their problems, and as far as possible, they will make an attempt to iron out things and make it easier for them so that they can enjoy the benefits which others are enjoying. So these are social benefits, the benefits which we need in the normal life. So being human beings, it's always possible to extend those benefits, and if there is any obstacle in the way, some minor problems arising, then they can be taken care of by this committee. But of course, the major things will have to come through legislations only. There can't be a generalized recognition to any sort of union or recognition to marriage based on any decision taken by this high-level committee. That will have to be a very important high-level policy decision which the cabinet will have to decide and bring about through legislation.
Yes, and the judgment also speaks of states giving protection to the queer persons from discrimination. They've also spoken of, especially Justice Butt's judgment has spoken of, not forcing any medical procedures or surgery on transgender or queer persons. The CJI's judgment has also given a slew of directions to the authorities on how they should be treated.
Important path-breaking issue is to what extent the court can direct the state to discharge its positive obligation to ensure that the fundamental rights can be effectively exercised by the people of India. That's the most important field.
Yes, sir.
Thank you. Yeah.
Sir.
Thank you.
Thank you, sir. Thanks a lot for your time, sir. And thanks for joining us despite you having been away from Delhi. Thanks for your time, sir.
Thank you. Thank you for inviting me.